Thank you very much, Judge Lavoy. What you see on the screen there is the text that was the subject of the 1983 referendum. That was the referendum to insert a new sub-article, Article 40.3.3, into the Constitution, often known as the Eighth Amendment. And you can see there what it says: the state acknowledges the right to life of the unborn, and with due regard to the equal right to life of the mother, guarantees in its laws to respect and, as far as practical, by its laws to defend and vindicate that right. And the paper that's been circulated to you and the talk today, the purpose of those is to give you a brief overview of the relationship between the Constitution and Irish laws on abortion. And there's probably two things to bear in mind at the outset. The first is that's a relationship that to some extent predates the 1983 referendum for reasons that will be explained in the talk and in the paper. And the second is that the question of the precise relationship between the Constitution and the law on abortion is one that has areas of uncertainty, areas of ambiguity. There have been uncertainties, there remain uncertainties about that precise relationship. And again, we'll touch on some of those uncertainties in the course of the next 10 or 15 minutes. So before the 1983 referendum, what was the legal position? There's a number of factors at play here in terms of understanding the position, understanding the public debate that led to the referendum. The first is the law on abortion in Ireland was governed by the Offences Against the Person Act 1861. Now what this did was it created a criminal offence for a woman who intentionally ended her pregnancy, and it also created a criminal offence for persons who assisted her in that process. And that, as you can see, it predated independence, and it was the law from 1861 and was the law when the 1937 Constitution, which is our current Constitution, was brought into force. That 1937 Constitution made no specific references to abortion. So the word abortion didn't appear anywhere in the text, and it was therefore unclear, or there was an ambiguity about the extent to which the Constitution had any implications for the law on abortion. Different judges expressed different views on this. A number of judges suggested, for example, that the right to life in the Constitution extended to the unborn. And if that was correct, that would have implications for example, the ability of the Oireachtas or of the courts to make changes to the 1861 Act. But these were suggestions, and the Supreme Court never gave a definitive view on this question. But that uncertainty formed part of the background to the debate of the 1983 referendum. The other factor that the Supreme Court has suggested fed into that referendum was developments in other countries, and in particular in the law of England and Wales and the law of the United States. And what happened in both those countries was courts gave decisions, the effect of which was to increase the range of situations in which an abortion could legally be carried out. And there were some important similarities in the legal backgrounds in relation to England and Wales. The High Court decision that did that in England was based on the 1861 Act, which was obviously the same legislation that applied in Ireland. In relation to the Supreme Court decision in the United States, that was based in part on the constitutional right to privacy, and the Irish Constitution similarly protects the right to privacy. Now, there was and there remains disagreement about whether an Irish court could or would have reached a similar decision and would have taken a similar approach to the English courts or the American courts. But the belief that an Irish court might do that informed the debate around the possibility or the merits of having a referendum to specifically address this question. And therefore, what did the 1983 referendum do? Well, the first thing it did was it clarified this question. It made clear for the first time in express terms that the right to life did apply to the unborn. What was the effect of this? Well, you can see the effect is summarised there, and these are two quotations that are taken from a Supreme Court decision in 2010 in a case called Roach versus Roach. And you see Mr. Justice Hardiman said the purpose of the article was to prevent the introduction of abortion either by legislation by the Oireachtas or by judicial decision. And Mr. Justice Gagan added that nobody could dispute the primary purpose of the referendum was to prevent decriminalisation of abortion without the approval of the people as a whole. And what that indicates is, as Mr. Justice Lavoy has reminded us, the Constitution can only be amended by referendum. So Article 40.3.3, like any other article of the Constitution, is binding on the courts, is binding on the Oireachtas. They're obliged to adhere to it and to remain within its limits until or unless the people decide to change it. So Article 40.3.3 is there and therefore applies to this area, and it would require a referendum if the view was taken it should be changed. And that's what Mr. Justice Geoghegan was referring to in that quotation. So that was the primary effect of Article 40.3.3. But if you recall from the first slide, the text of Article 43.3, it's quite general. And it raised more general questions. What are the other effects? What are the general effects aside from this specific question of abortion? And the language of Article 40.3.3 is very broad. It talks about broad concepts like the right to life of the mother, the right to life of the unborn, without giving much more in the way of guidelines or detail about how that operates. That's not unusual for a constitution. Constitutional documents are typically expressed in very general language. They often confirm or speak about broad principles, but don't give much guidance about details. And where there is a lack of clarity or an uncertainty about what that means in practice, it's often dealt with in one of two ways. By legislation, where the Oireachtas provides further details, further guidelines, or the courts may also provide clarification. And in relation to Article 43.3, some of the issues, some of these more general questions that arise or that are left open by the text. Is Article 43.3 only about abortion? The short answer to this is we don't know. Different judges have expressed different views on this issue, but as of yet we don't have a definitive Supreme Court decision or legislation that specifically addresses this, and therefore that, for example, is an area that is somewhat uncertain. What does the unborn mean? Here we have partial clarification on this question. The Supreme Court in that 2010 decision in Roach versus Roach were required to consider whether an embryo that had been fertilised during an IVF process but which hadn't been implanted, whether that was unborn within the meaning of Article 40.3.3. The court decided that it was not, and that gives us some clarification. It suggests that embryos in that situation are not unborn within the meaning of the Constitution, but there may be some other specific situations that there remains some uncertainty about. In relation to the last question you see there on the screen, what does the equal right to life of the mother and the unborn mean? This was an issue arising from the text, where the text talks about the right to life of the unborn and the equal right to life of the mother, but doesn't say anything about what should be done in situations where there may be some tension or some conflict between those rights. And that arose in a decision in 1992 in Attorney General versus X, more commonly known as the X case. And the situation here was a 14-year-old rape victim who'd become pregnant as a result of the rape. The question that arose was whether she, well, a number of issues, whether she was entitled to have an abortion as a matter of Irish law, whether she could travel to have an abortion, or whether Article 40.3.3 prevented and precluded her from taking either of those steps. The High Court found that she was suicidal and there was a risk of suicide from a continuation of the pregnancy. And therefore, the factual situation gave rise to this conflict, where there was a tension between the right to life of the unborn and the right to life of the mother. And what the Supreme Court decided in that case was as follows. They decided that Article 40.3.3 did allow for abortions to be lawfully carried out in certain situations, where under the Constitution, as a matter of probability, it could be established that there's a real and substantial risk to the life as distinct from the health of the mother, and the risk can only be avoided by the termination of the pregnancy. In terms of what constitutes a real and substantial risk, the court accepted that that could be either a risk from a physical condition or a risk from suicide. And therefore, in her situation, she was entitled, as a matter of Irish law and under Article 40.3.3, to have an abortion. These criteria are important because they remain the position at present. So at present, under Article 40.3.3, abortion is constitutionally permissible if those criteria are satisfied. And as I say, that's the current position, and therefore that's the position that informs your deliberations in the sessions to come. There are, however, some further developments that you should be aware of in relation to those criteria. The criteria in X about when an abortion may be permissible as a matter of Irish law. There were two referenda, 12th and the 25th amendments, which suggested changes to those criteria. In particular, they suggested confining the risk to a risk from a physical condition. In other words, the risk from suicide would no longer have been permissible. They were rejected by the people in referenda. There was also, in relation to the X criteria, a question around, again, an ambiguity or a certain lack of clarity. While the Supreme Court had indicated when or what criteria had to be satisfied, there was no further information about how, for example, who made that decision. If a person felt they might come within the criteria, how would they find that out? And therefore it was suggested by a number of the Supreme Court judges in X, and also in the Roach case, that it might be helpful to have legislation on this issue. In 2010, the European Court of Human Rights, in considering 3 complaints, or complaints from 3 women about Ireland's abortion laws, found that one of the women, her rights under the European Convention on Human Rights had been breached by this lack of clarity, by the lack of detail and procedure. And in 2013, the Oireachtas passed the Protection of Life During Pregnancy Act, which I understand you'll be hearing a bit more this afternoon, and which basically sets down some more detail about the procedures and the guidelines that regulate the application of the criteria in X. The other developments to bear in mind, following the X case, there were also referenda held on the 13th Amendment and the 14th Amendment. These relate to travel and information. So the 13th Amendment, and these were approved by the people, the 13th Amendment confirms that if a woman is otherwise entitled to travel and to leave the country, she can't be prevented from doing so on the ground that she may have an abortion while she's abroad. And in relation to the 14th Amendment, that confirms the availability of access to information about abortion services in other jurisdictions. And the details of how that works were fleshed out in the 1995 Act. So much like the 2013 Act gives details about the X criteria, the 95 Act gives details about how the rules on access to information work. What that also means is, because the 13th and 14th Amendment have been approved, the text of Article 40.3.3 has changed somewhat. You see, you still have the original 8th Amendment in the first paragraph, but you now have these additional paragraphs that confirm the rules relating to travel and the rules relating to information. And so this is the text as it currently is, and that's therefore also the text that will inform your deliberations today, tomorrow, and over the course of the coming sessions. Thank you.
I'm very grateful to Dr. Carolan for giving you a very, very clear overview of where we are on the topic we're concerned with. You also have his very, very useful paper, which gives you more detail. And there is a lot of detail in it, and it may be difficult enough for non-lawyers, but I would really ask you to consider that paper, and also to consider the 3 additional papers which I referred to earlier. There's the last one I referred to is, in a sense, a summary of the current position, and that was prepared by 2 lawyers in our expert advisory group, Oran Doyle and Rachel Walsh, and that you will find helpful, and I think we'll be referring it to it no more than to Owen's papers in later dates. And then there are the other 2, the timeline and so putting the article, the provision, the 8th Amendment that we are concerned with, into the context of fundamental rights. And I brought this. This is the most important document you will have, and what you've been given is the October 2015 edition, which brings it right up to date. So I hope that the appendix that sets out the fundamental rights, I hope that will give you an insight into the entirety of that part of the Constitution. But as I say, this is the important document. Thank you very much. It's now break time.